another question that I keep getting, Chris, is clients are calling, they're suffering from injuries, they're suffering from illness, and they don't know if they're protected. They might not feel that they're disabled and that they're entitled to protection. Chris, can you talk a little bit about disability discrimination and who's protected from it?
A lot of people don't realize that they fall under the category of disability or disabled under New Jersey or federal law because there are some connotations that surround it. People think that it's something that's much more severe than it is. So when we're talking about disability discriminations and protections from disability accommodations, under New Jersey law and the law against discrimination, any type of condition that interferes with a major life activity, and that could be something along the lines of being able to walk, stand, sit, or work. Anything that falls into those categories must be accommodated if a reasonable accommodation by the employer can allow you to perform the essential job functions for the position that you hold. So often, what does that look like? Sometimes when people are sick, maybe they need a surgery, they might need time off from work. Other people, maybe in the example of pregnant people, they might need accommodations like bathroom breaks, right? Everyone's different. The accommodation that everyone needs is different. But once you put your employer on notice of the fact that an accommodation is needed, they need to engage in the interactive process. Mark, we see the interactive process issues come up all the time.
And the interactive process is an important thing to talk about too, because employees don't always know what their obligations are and what the employer's obligations are. Employers have to try to accommodate you. Even if they can't do exactly what you request, they have to try to offer alternatives and they have to engage in a dialogue for you. But employees have to be careful because they have to carry their weight as well. You can't just send out one request to an employer. They have follow-up questions. They ask for documents and then you don't get it to them. We get a lot of employees, unfortunately, who end up damaging their own cases because they didn't follow through with simple requests. The employer is asking you questions about your medical condition or your leave. You need to either answer them and engage, or you need to call an employment attorney and get advice as to what exactly you need to do to make sure that you're fulfilling your obligation and you don't end up hurting your own case.
You can't wait 2 months to get the doctor's note in, right? Or you can't be out for leave for a couple weeks before you tell your employer you have a serious health condition. And when it boils down to this, the guiding principle, I think, most often is being reasonable, right? And there's this expectation of good faith in all of these endeavors. Now, Mark, one type of case that we see often come up, and I use the hypothetical situation of our many truck driving clients, right? So you have someone comes to us, he works for a trucking company, he requires time off for some type of medical condition he has, won't get into specifics, and he produces a doctor's note that says that he needs 2 weeks off for this medical condition. Employer puts him out of work for 2 days and fires him. In that type of situation, what else do you want to know from the client? What really tees up whether or not there's a case here?
We're going to want to know what the medical condition is. We're going to want to find out what exactly he needed to be off of work for, because that might determine what type of case he has. Because depending on what medical condition you have, you could be protected under the Family Leave Act. You could be protected under the New Jersey law against discrimination. You could be protected under the New Jersey paid sick leave law. So it's important for us to know, medically speaking, what that employee was suffering from, and also what else the employer asked him to do. After they submitted the doctor's note, did they ask for anything else? Did they end up not submitting information that their employer needed? Did they not follow through on the call-out process? We are able to check all those boxes and show that our client did nothing wrong. Then it's extremely likely they're going to have a cause of action. They're going to be able to bring a claim. The only question will be, which law does it fit under? And that's where we'll undergo the analysis and figure out what's best for our clients.
And often we also see that what precipitates this, what comes right before this, is that the client actually got hurt at work, right? The medical condition stems from a workplace injury. The claim is filed on Monday. Next thing, they're terminated on Tuesday. What causes of action might additionally come from that?
Well, then we set up a whole chain of events on retaliation claims, because there's separate retaliation claims for pursuing workers' compensation rights. Even if you haven't filed a workers' compensation claim yet, but your injury happened at work and you're getting ready to go through the process, you can't be fired. Then Also, if you need time off of work, that sets up a LAD retaliation case because you needed a reasonable accommodation and they didn't allow for you. What's important is that the employee clearly pursues their rights, does it in writing whenever possible, and is able to justify the fact that they didn't deserve to be terminated, because the employer will come up with some reason to be terminated. And that shouldn't dissuade you, because just because they offer another reason, just because they try to blame you for something, we see it all the time. Employers try to blame employees for their own accidents and say that that's why they're terminating them. Don't get discouraged, because oftentimes we're able to disprove that and we're able to bring claims either way.
And often we have that conversation with clients. Once we get the rebuttal from the employer, look, I just sit down, don't get angry, wait till I'm done telling you this, because I'm not here to just tell you that they came back talking about why you're a terrible employee, you deserve to be fired. But what I need to hear from you, client, is why is it false? How can we prove that the reason that they gave is false and just pretext that was given as a reason for terminating you? We got to work together. This is part of the lawsuit.
And I just had this conversation with someone the other day because it took them a little bit of time to get to us. And I said, what took you so long to pursue wrongful termination? And they said, well, they wrote me up for when I got injured for violating a safety rule. And very technically, by the letter of the law, I did. So I didn't think that I had a case. So then I started asking them questions. I say, well, were you trained on the safety rule? He said, well, not exactly. My training was pretty laissez-faire, and we didn't get trained on this exact rule. And plus, everyone did it my way. It was kind of the unspoken policy, and none of those people got fired. Well, now all of a sudden they have a case, because it shows that they were treated differently because they were hurt. And also there's what's called the mixed motive theory, where we can show, even if maybe you did break a rule, or maybe you did break a policy, but what pushed it over the edge, what caused you to get terminated, was discrimination or retaliation, then we're able to bring a claim. So I often tell people, don't get discouraged. Don't buy the reasons why they're giving you for your termination, and whatever documents they try to show you when you were terminated. It's important to speak to an employment lawyer.